Yeah.
I can hear it.
Yep. Hello. Hi. Welcome, folks. Wonderful to see you all. And I'm so excited about this day and tomorrow because we're going to talk about children's rights. And that is one of the most important rights in my research. My name is Marit Skivenes. I'm a professor here at the university. I am the head of the child rights units at the Law Transform, and I'm the director of Center for Research on Discretion and Paternalism. Next year, it is 30 years since the Convention of the Rights of the Child were established. And the convention has universal support, which is just amazing. It is all countries, except partly from the USA, that have ratified this convention. And that is in itself a very, very important landmark. So children are now formally lifted up to be on equal footing as adults in our societies, in all societies, and that matters. This is an immensely important step in the modernization processes of societies. Children's rights concern a huge group of people. It's actually 2.2 billion children in the world, and that is about 30% of the population. That's a lot. Also, we know that children are a huge part, then, of the global challenges that we face. Children are often the victims of some of the major crises and conflicts that we are meeting today. And I want just to show you two examples that I think that you all know a lot about. The one on the left-hand side, that is the present conflict in the USA. And this is the direct effect of the politics of President Trump. Children were separated from their parents at the border. Clearly, this is a violation of children's rights. It doesn't matter. Secondly, we do see that this is the Mediterranean, where we have the refugees and the migrants in boats. It's a huge, huge challenge for us. At the moment, Italy and Greece, they do not want to take them. Spain has now been a major port for these boats. It's a conflict in the EU, and they discuss it continuously. We know that many, many of these migrants are children. Many of them are also unaccompanied children. They are alone. So we have clear violations of children's rights. What we are going to do today is that we're going to discuss some of these violations in various societies. We will have also a discussion around what can children bring into our societies. How can they empower us? How can they make changes? And we will have some excellent examples of how children and children's organizations are making movements and making changes. Today, we will have a lot of international experts talking on children's rights. We have the elite of practitioners and we have the elite of researchers. Many of my colleagues and I did it. Well, that's technical good. Many of my colleagues from the Center for Research on Discretion and Paternalism will be giving introductions today, and they will also be the moderators of these sessions. And I'm very much looking forward to the days that are coming, and please feel free to ask questions. Please feel free to connect up in the breaks that we will have and speak with both the practitioners and with the researchers that we have here. First out is Jenny Kritziner, my colleague, and she will start out with a session which is called Children's Rights to Child-Friendly Justice. Okay, welcome.
Great. Okay. Thank you very much. Good morning, everybody. It's a pleasure to be here on behalf of the IDEA project, presenting a little bit of a brief introduction about what we're working on in trying to build the capacity of professionals working in the area of child protection in particular to do their work in a manner that is children's rights compliant. So I'm just going to briefly introduce the project, the team who are here, and then having done that, I'm going to be handing over to partners from the various universities to talk a little bit about the lessons learned by the project in each of the 5 countries. It's a 5-country partnership, so the aim of the project, as we see here, is Jenny read out the acronym earlier on, to aim to improve decisions for children through empowerment and advocacy, through empowering both the children themselves, but also empowering the professionals to be in a position whereby they can advocate for children more effectively. And it's a 5-country partnership. So it's led from Ireland by University College Cork. So there's myself, my colleague Kenneth Burns, who's sitting here in the middle of the room. And then we also have partners in Finland. We have the University of Tampere in Finland. So we have Tarja Poso and Laura Kalioma. Then we have the University of Gothenburg in Sweden. So in the front row here we have Stefan Hoyer and Elin Hultman. We have the University of Tartu in Estonia, who's represented by Katja Luhama. And we have the University of Szeged in Hungary, who's represented by Dora Laiko. So you'll be hearing from all of those as the morning goes on. And so what we're doing, it's a 2-year project co-funded by the European Commission, a €500,000 project over the 2 years. And we are essentially trying to establish what are the training needs of professionals working in child protection, because the common thread that we found running through all of the different countries is that while countries are quite good at passing laws that say children should have rights, countries are a lot less good at doing the more difficult unseen work to try and ensure that professionals are actually able to translate those laws into good practice. So a simple example would be that lots of countries pass laws saying that children have a right to be heard in court proceedings, but then those same countries don't provide the necessary training to the professionals involved in those proceedings so that they are actually effectively able to communicate with children. So clearly the law is not going to work very well if you don't put in that extra work, which is sometimes, as I say, it's less visible. Politically, it's probably more difficult to get credit for it. A politician can get a lot of credit for passing a law, but maybe doesn't get as much credit for doing this behind-the-scenes work to provide the necessary skills to practitioners. So we're trying to establish what are the training needs of professionals, where are the gaps in the training that they've been provided that act as barriers to them working in a manner that gives effect to children's rights. And we're then trying to develop and deliver training which fills those gaps in simple terms. So a big part of our project, really probably the defining feature of our project, is that our focus is very explicitly interdisciplinary. So it is a joint law and social work project. It was designed like that from the beginning. So all of the partner countries have representatives on the team, both from law schools and from social work schools. And so we made a conscious decision from the beginning to bring those 2 disciplines together. And that's been one of the interesting things. And perhaps some of my colleagues will speak more about that as they address each of the countries. But that interaction between law and social work and what the 2 disciplines can learn from each other, the different perspectives that they bring to issues of child protection is at the core of the project, and is a particularly interesting feature. And so the training sessions that we developed, then we are again deliberately trying to bring those perspectives together, drawing on practitioners and leading researchers from both disciplines. So we've had, for example, Professor David Shemmings has gone to all 5 countries and given a masterclass on child attachment theory, coming from that particular perspective. From a legal perspective, we've had Professor Anne Skelton from the Centre for Child Law in Pretoria in South Africa giving a session on strategic litigation. So that's obviously much more focused on the legal part of the picture. We've had Professor Laura Lundy talking about models of child participation. And then we've had many other components to our various training events. In some countries, what we've done in Ireland, certainly we've made a particular effort in our sessions to always have the lawyers and social workers in the same room at the same time. So rather than having sessions where we meet all the lawyers one day and all the social workers another day, we want to bring them together and put them in the same room for a day and sort of lock the door and leave them there. Because in some ways, even aside from the formal part of the delivery of the training, there is the interaction that goes on during the roundtable discussions, during the coffee breaks and the lunch breaks and so on, where you get those people speaking to each other and gaining a better understanding, lawyers having a better understanding of what are the social workers thinking and where are they coming from, and vice versa. I'm going to give just a couple of very brief examples of the work we've done in Ireland before I hand over to our colleagues. So as I've just mentioned, here in Ireland, certainly when we started out and we did a survey at the beginning trying to establish what the training needs were of the professionals working in the area, and it was a very strong message that we got back from about half of our target audience saying that they would like to learn more about the roles of other professionals working in the area, and that they had gaps in understanding, that the lawyers were saying they didn't understand enough about child development or child welfare theory or attachment theory. Equally, social workers were telling us that they didn't understand enough about the law, that they weren't fully up to date with the latest legal developments. But even the lawyers in some areas, lawyers would tell us that they were very strong on issues of domestic law, but perhaps were less well-versed in international human rights law, which of course can be extremely important and an extremely powerful tool in the area of children's rights. So all of that feedback you'll see as the presentations go on has fed into the types of training that we have developed. And another key message that we got back in a very strong way was the impact of this work on professionals. So professionals working in child protection who are exposed on a daily basis to issues of severe child abuse or child neglect. This has a very significant psychological and emotional impact on those professionals, which over time leads to burnout. And the support mechanisms which are in place to help professionals in child protection to deal with that perhaps are not always as well developed as they might be. So that's something else that we've had to try and consider and feed into it. One or two examples of things we've done. Obviously, you have training sessions which are quite traditional training sessions where you bring in a leading expert or a leading practitioner who speaks to an audience for a period of time. But we didn't want to just do that. We also wanted to try and give people things which, when they leave the room, they can take back to the workplace and which will help them to bridge the gap, I guess, between theory and practice. So we've worked on developing practice tools which are designed to make it easier, really something, a practical thing which people can use in their everyday work, which makes it more likely that the sort of children's rights issues we want them to be working with are going to feature into their work and improve their work. One example, I mentioned already that we received feedback from lawyers around the idea that they didn't have as good knowledge or as good understanding of international human rights law as they did of domestic law. And certainly in Ireland, it's been an observation I would have had for a long time that the European Convention on Human Rights has huge potential to offer in the area of children's rights, but is not utilised as much as it could be. And often, by the time people find out that their children's rights claim is going to fail in domestic courts and decide, oh, maybe we could take a case to Strasbourg, they have made some decision along the way during the domestic proceedings that leads to the final application to Strasbourg being declared inadmissible. And so we thought, we'd like to try and address that, try and ensure that people are running their domestic cases in a way that doesn't ultimately close the door on Strasbourg later on. We want to clear the path to Strasbourg a little bit more. So we developed this checklist, which I have some copies of if anybody would like one, and you can download it from our website. And the idea is it's a simple tool which practitioners can attach to a file, 6 simple steps that they have to just make sure as they run the case domestically, even though you might not be thinking of taking a case to the European Court of Human Rights now, you might want to later. So are you doing these things, or are you avoiding these pitfalls now, so that if you do decide to take a case to Strasbourg later on, you won't find your case being declared inadmissible. And of course, over 80% of applications to Strasbourg are declared inadmissible. So this is designed to try and avoid that particular pitfall. On the staff welfare side of things, we also developed a practical tool. So I mentioned that we had this feedback from the practitioners around the lack of support they have to build their resilience in dealing with the stress and trauma of working in the area of child protection. 79% of our practitioners in Ireland had received no training whatsoever in how to deal with and cope with the trauma of working in such a difficult area of work. And you see some of the quotes from our participants here talking about how difficult they find the work, the impact that this has on them. Burnout is a big problem. And if you want to have a system which has the capacity to deal with children's rights effectively, then obviously you need the people working in that system to be able to work effectively. And they're not going to be able to work effectively if they burn out. One simple example in Ireland would be the issue of retention of social workers. Huge numbers of them leave the profession because they simply find the work too difficult. So again, we're trying to think about what can we do as a simple, practical measure to try and, it's not going to solve all the problems, but is there something we could do to help people to, in their day-to-day practice, build resilience and better cope with the stress of the job, which led us to develop the Spark tool. So after doing a lot of research into this type of work and falling off the stage, so we came up with this tool, which is a simple, diagram, for want of a better word, which somebody can fill out, which helps them to identify what are the things in my day-to-day work which are causing stress. What can I do about those things to alleviate that stress? And it's a reflective tool, so that it's something which somebody would do on a regular basis every couple of months. And they finish up by listing, and on the back of the form, you formulate a self-care plan whereby you identify what are simple things I could do which are going to assist me to build my resilience and build my capacity and allow me to better cope with the demands of the work. So as I say, they're just two simple examples of things we've done which are trying to, rather than just bring people into a room and speak at them for a couple of hours about theories of resilience or mindfulness or whatever else, but something practical that they can take back to the workplace, share with their colleagues, and hopefully allow them to build this into their work on a day-to-day basis. So they're just a few examples. But it's a much bigger project than that. The range of things you see there, that's the full list of training topics that we have, which span areas of both law and child development and welfare, as well as staff welfare. So we've been, for the last 2 years, we've been quite busy now. We're approaching the end. We'll be finishing up in January, and we've at this stage, we have run quite a number of training sessions across all 5 countries. And so we've picked up on a lot of lessons in the feedback we received from the practitioners about what works and what doesn't work. So really, as I say, my purpose was just to introduce the overall project, but now I'm going to hand over to my colleagues who are going to say a little bit more about particular specific lessons learned in each of the partner countries in the course of delivering that training. Okay, so thank you very much.
Hi, hello. Not really. I can take the other one otherwise. You hear me? No. You do? Also from. Okay, we're good. All right, good. All right, I'm Stefan Hoyer from Sweden. And yes, we did training sessions in Sweden. Yes, we did surveys. But in order not to just get repetition, we'll try to tell you about some lessons learned from our project in Sweden. And me and Elin will focus on 2 things. The first one is the use of laypersons in decision making in the Swedish child protection scene, and whether or not this affects children's participation and child friendliness in these procedures. I'll talk a few words on this, and then Elin will come and talk about the different age limits according to the law when children have a right to be involved and to have their views heard. But she will come back to that in a minute. As far as we know, Sweden is the only country in Europe where laypersons have such a dominant role in decision making in child welfare and child protection. I know you had it in Norway before, you changed your system and you still have some laypersons, but in the Swedish scene, when it comes to voluntary placements, the Social Welfare Board has only laypersons on it, and they make the decisions about child protection issues. Okay, from an investigation of social workers, but still they are the only decision makers. And when it comes to non-voluntary proceedings, when it comes to court orders in the courts, the judge has 3 laypersons by his side or her side to make the decision. So even in that forum, the laypersons are the dominant ones. So what does this have an effect? Does this matter when it comes to the decision making? That's our question. Is it advantage or not for the children? Well, in the boards, children never are questioned separately by the laypersons, or at least we didn't get any examples of this from our laypersons from the board members, because we had them in our training sessions. The laypersons are likely to feel they represent the citizens in the municipality in relation to the professionals. And when they think citizens, they think grown-ups, they think parents. So they identify with the parents, not the children. And when it comes to the administrative courts, the judge do all the questioning. The laypersons may pass on a question or two to the judge, but they are not free to actually ask questions directly to the children themselves. So our first, well, what we think about this is that even if they have attitudes that children should be involved more, when you ask them about that, when you look at their practice, the system with laypersons seems to make it more difficult for a child-friendly justice. And then, Elin.
I had some pictures. There? No. Okay, I had some pictures, but I don't. I don't know what it's named. Could you help me, Annie? Okay, I'll start. During this project, one thing that has become clear to us is that main actors involved in the child protection proceedings, lawyers, social workers, and laypersons, can view children's right to participate differently. And we will give an example from the survey carried out within the ID project, where we had a specific question about age. In domestic legal regulations in Sweden, it's made clear that all children have the right to be heard. However, in cases of involuntary out-of-home care, there is an age limit. To have the right to litigate in court in such cases, the child has to be 15 years old. And in the questionnaire we asked, do you think that this age limit would be reduced and also include younger children? And as you can see, when a child is seen as old enough to speak for herself, is viewed differently. There are differences between the groups, but also within the groups, and there are quite a lot of persons, especially the lay persons and the social worker, that are ambivalent and answered that they don't know. I will also give you some examples of they could write a comment to their answer, and this is some examples of persons who answered yes. And they, for example, said that also younger children can have opinion and it is important that the child feels respected. Another one said that if the child is mature enough and express a wish to take part, the age limit would be, they think, is a reason for the age limit to be reduced. If we look at the no answers, another person said that it's questionable if children younger than 15 years old are mature enough. Another one says that I think that the environment in court is too formal and scary for younger children. And finally, an example of a person who answered don't know, and that person said that there should be an assessment based on the age and maturity of the child. So, as you can see, when a child is seen as old enough to have the right to legislate in court, it's viewed differently, and the reasons for why also differ. However, one thing that seems to be important is the maturity of the child. This is mentioned in arguments both for reducing the age limit, to keep the age limit, or among the persons who are ambivalent. So it seems to be the maturity, not the age in itself, that is important. However, the respondents do most often not specify what kind of competence they think is important. And if they do not tell how the child should be able to prove that they are mature enough. So one conclusion that we draw from this answer is that there is a risk that children will enjoy the right to participate only if adults agree on it. And this means that children's participation depends on the main actors that are involved in their specific cases. So we think that it's important to continue to discuss what we mean with maturity and how we view children's right to participate in relation to age and maturity. And maybe also we could discuss why maturity for children matters when it is nothing we discuss in relation to adults' right to participate. Thank you.
This working now? Yes, thank you. Okay. So the Finnish team wanted to bring up a theme on cooperation and trust between professions. We all know, there are a bunch of professions working for the child's best interest in child welfare proceedings. And in order to reach child's best interest, it's mandatory that this cooperation goes smoothly. And in order to go smoothly, it means that these professions should trust each other. They should trust that the other professions do their role well enough, and also trust them in order to communicate smoothly. So we asked in our questionnaire that what do these professions think of each other? They answered, not very surprisingly, that the cooperation is easiest within one own professional group. Then we asked them that, do you trust the others' ability to take care of their duties and their ability to look for the child's best interest? And again, not surprisingly, they answered that they trust that the other people in their own profession are able to do that. Everyone trusted, the highest points went to the court members. So all the professions trusted the court members. But no one trusted very much the attorneys, not even the attorneys themselves didn't trust the other attorney. And when we asked them then what is the biggest problems with this cooperation and these trust problems, they said that communication skills and, surprisingly, respect of other professions. So one could translate perhaps that people didn't behave well enough. They weren't polite enough. The communication didn't work because they felt a lack of respect. Also, there was lack of child-centered working methods recognizing the common target. And again, knowledge of the roles of the other professions, what Conor already brought up, and reserving enough time for the cooperation, and difficulties simply in reaching the other professionals. Well, we also asked that what do they think that should be done in order to cooperate more successfully. And they said, you could squeeze the answers into 3 points, that they thought that the one answer would be clearer roles, obviously more resources, and then common trainings. And I think that is the point that we should learn from, especially because multi-professional education in both basic education and post-graduation trainings is not that common, at least not in Finland. And that's what we've been trying to do now in our IDEA project. And at least the participants of the Finnish IDEA trainings have valued exactly that. They have, in their feedback so far, they have not valued that much our great speeches or our other trainings, but they have time after time brought up that the most valuable thing is the chance to meet each other, to talk to each other, to share views, to learn from each other. And I think that's something that quite easily, perhaps, we could bring into even to the basic education and also to adult trainings. Thanks. Now I think it's Dora. Yep.
Like a singer. So, good morning to everyone. My name is Dóra Lajkó, and today I am the key speaker of the Hungarian group of IDEA, but I'm not the only Hungarian person here from this group. Let me introduce my colleague. Her name is Erika Engi. Let us see the Hungarian experience of our IDEA trainings. Our experience was that there would be a great need for this type of education, because in Hungary, the majority of the trainings for child protection experts focus either on law or psychology, and these trainings are lecture-oriented or training type. But we combined the knowledge of jurisprudence and psychology, and at the same time, we presented a strong dogmatic system using training tasks. What's more, every training had a part of resilient development and ventilation case discussion. So thanks to this complexity, the participants of our trainings could learn about coherent knowledge from various disciplines in a uniform package, and get a new inspiration, and the experts from each profession could open up for each other, and they try to understand the special characteristics of the given profession with empathy. For example, the pressing burden of deadlines or the uncertainties resulting legal gaps. Our other experience was the astonishing lack of communication among various experts in real life. In Hungary, these professions have closed rules of procedure, but in our trainings, the participants from different professions could experience the great strength from being able to communicate with each other. Unfortunately, this was maybe the only forum for them. Our third experience was that the methods of staff welfare do not work at all in Hungary in practice. This has unfortunate consequence in practice that these experts burn out very quickly and search for another job. In addition to mental burdens, this job leaving is increased by the fact that the social appreciation of child protection experts' jobs is almost nothing in Hungary. This is also true for the profession of judge, which otherwise enjoys social appreciation. But those judges who deal with child protection, family issues, are the lowest in this rank. Due to this, child protection struggles with a constant lack of experts. So it does not predict a network of stable, motivated experts in this area. Our fourth experience was that we found that the rights of children do not prevail in life. Sometimes in practice, these rights are stuck in the catalogue of the acts. The majority of the parents are uninformed, and the experts know these rights, but they are uncertain how to bring these rights to life. The need for the mental changing is of great importance, as law is not a restaurant meal from which half a portion is sufficient for a children. The fifth experience pertains to organization issues. Unfortunately, we had to realize that we had not good enough at marketing, because there were places where our training were full, but in some other places it was not. Besides this, we concluded if we had made this training fee paying, probably it would not have happened that the registered participants canceled their application the previous day. Our last experience was that Hungary is deservedly famous for bureaucracy, because we had to do a lot of administration for our university besides the European Union account. And however, I can say, or we can say, that not only the participants' resilience improved, but ours too. So I would like to thank the Hungarian group for their enduring work, and especially Erika, who made the administrative text. But in spite of all the obstacles, it was worth going through it. So thanks to the international group of IDEA for this great opportunity, and thank you for your kind attention.
Hello, I'm Katre Luhamaa, and I'm representing the University of Tartu here, although I'm currently working for the Center for Discretion and Paternalism here in Bergen. And I would like to conclude the presentations of IDEA project of perhaps bringing out the unexpected results of fulfilling an action grant. Action grants are this kind of short-term projects, only 2 years to fulfill a project, that has to bring up some kind of practical results for the practitioners. So the question is, why should a university, and these were 5 universities, why should a university take up this possibility and apply for EU money and try to find some co-funding and go through this rigorous process and very fast-paced process. And for Estonian team, I think there were 3 main results in practical terms, what were a bit unexpected, but nevertheless, I think very important. Firstly, having this direct contact with the practitioners, both through the surveys as well as the training sessions, really gave us the possibility to understand where the laws of where the flaw of the law as well as the practice is. For example, in Estonia, child removal proceedings include obligatory participation of a lawyer, but it became apparent that lawyers actually don't know why they are participating in these proceedings, what their tasks are, and what is their procedural status, other than just to be in the courtroom and say the same things as the social workers. Secondly, it brought out the importance of cooperation, but not only cooperation between the practitioners, but also between the police. We had unexpected amount of police workers, police officers coming into our training sessions and saying that we are also very much part of the social security system. We are involved in the child removals. Please take us also on board. As well as inclusion of judges, possibly for the practitioners, it seemed to be very important that future trainings would also include judges as well as experts, other experts, psychologists or then other professionals who are included in the proceedings. Secondly, we realized that having this kind of training sessions where you allow the practitioners to speak is actually a form of focus group research. And I think it gave us a lot of ideas for future research. What are the lacuna in the research, in the knowledge, in the understanding of the system? Where do the practitioners themselves see the limitations, as well as what kind of research would they like to see? And also creation of this kind of common language or common frame of reference between law and social theory was very useful to introducing different types of researches, for example, social work research to lawyers, as well as legal research to social workers. So I think that in a way we gained a lot of ground or possibilities for expanding our research results and giving them to a wider audience. And thirdly, it was a perfect opportunity to see our academic education in work, in practice, as well as identify the flaws of the academic education that we give these practitioners. In Estonia, it was the fortunate event that all the lawyers were former students of the law faculty of Tartu, and most of the social workers were former students of the different faculties of the university. So it gave us an understanding of what the academic education lacks, where could we improve, as well as how to further carry out continuing education for professionals. So even though action grants are difficult, they bring very exciting results, as well as give a lot of ground for thinking in the ways of how to do research better. Thank you.
Yeah, okay. There will be an opportunity to ask questions to the IDEA project at the end of the session. So I would like to hand over to the Change Factory now and hear their presentation. And then we'll hear Julia with the African perspective afterwards. And then hopefully we can open up the floor for some interesting questions. Thank you.
If you take one to I take.
Thank you.
Hello. Nice to be here, and thanks for inviting us. My name is Frederick. I live in Oslo, and I like to speak honest, and when it's safe enough in a room to speak honest with other people.
Hello, my name is Gloria, and I like to walk, go in the trips and just have music in my ears, because then I don't have to think.
And hello, my name is Marit, and I like to meet kind people. This is, we just tell you some few sentences, I think, about the Change Factory. It's an idea. Wow! Anything wrong? No? Okay. So we just go. We started this factory 15 years ago, and the whole idea. Okay. So you can do that. This is the idea. The objective is in the bottom. So the idea is to invite children to describe their experiences from meeting systems. Different systems for children. One of them is the law system, or the justice, this system, but also it's the children in care system, the mental health system. It's all about getting their knowledge and their advices to develop the systems for the future. And we summarize this knowledge, but we are not analyzing it or interpreting it. I have a ordbok. So it's not research. We are not researchers. We are communication people. I'm social anthropologist. So it's the whole thing is about listening with big ears and warm eyes. Yeah. Yeah. And this is what we are doing. We are collecting experiences. Then we are when we are traveling around in Norway, we meet young people, children and young people, and then we collect. We call it to collect information now, even though it's not research, but we do it so the researchers can understand what we're doing, maybe. Sorry. It's only because we are doing it in quite big numbers. But then we are not presenting it as research. We are presenting it as summarized knowledge from children. And then the children and the young people, they are presenting it, like we did, for example, yesterday in Trondheim. Gloria?
Gloria.
Oh, sorry.
Like yesterday, we were in university in Trondheim, NTNU, and had this kickoff for 3 of the, what's the name? Social work educations. And we're just kicking them off in the first year, because they have to have like this ground floor with knowledge from children when they're going to learn a lot of other things from books and scientists and stuff like that. They have to also have children knowledge like in the bottom.
Because when we listen to children around in Norway, in meeting these different systems, we know that some of these answers, they are for students. Some are for politicians. Some are for the lawmakers and so on. So we have to present it in the right place. That's something we learned early in Change Factory. If you present it the wrong place, all people get very sad. Sure, because you have to present it for someone who can change. And then you see there. We do it also. We meet politicians quite often. You can change. And these are the numbers. And we meet them. We are not sending questionnaires, because children taught us that we shouldn't. Sorry. But we developed the methodology together with children, and then we tried very hard afterwards to go on with this methodology. And in this methodology, I think maybe it's coming. Okay, this is coming first. I can tell you a little more about it. But this is Norway. They are presenting it all the time. And I don't know if you do in other countries in Europe, but it says the welfare service should be developed with 3 different types of knowledge. And it also says for the other system, health system, should be developed. And now we are asking Norway, how can this be true? Who is responsible for collecting the practice knowledge? I don't know if you have it in other countries in Europe, but we don't have a center, I think, with knowledge from professionals. And we didn't have a center with knowledge from children. And then we have some research center, and we are very happy we have. But if this is going to be true, how can we solve it? And we asked the ministers about it, because they are presenting it all the time. And we said, okay. So then we tried to be kind to Norway and said, you can have a gift. We opened a center with children's knowledge. So we did, and the Prime Minister, she came. Fredrik or Gloria, you wear the dress this day?
I never wear a dress, not in Christmas even, but I did that day. And that's because it was a very important day, because We make a lot of systems in Norway, and we make a lot of things for us, but we forget to ask us if that's what we want and how are we going to make it. And that's why this was so big day, because our knowledge is important, and it's important that it comes from us.
Yeah. And the methodology is, to just say 2 sentences, it's lots of different methodology, and the way the tools are made together with children. And if not, we could talk a lot, because I would like to sit around in Norway and talk to young people and children, because I like to talk. But lots of children said we shouldn't talk. Not talk so much, because if you talk, you have the power, because you most often know better how to talk. So this is one, I think this is the tool we use the most, because I think, and I can say in front of the court, all children, they want to take pictures if the question is okay, if they understand the question.
And if it's important enough.
And if it's important enough for them. So this is the methodology thinking. This is in classroom. We go around in classrooms, and then they show their pictures. They work in groups. The groups, it has to be safe. So we have to do some things to make it safe. And then they present for each other. This is about bullying. And this is one thing we found out in Norway. We have so many programs to fight bullying, but none of them are made by children. And the children's answers are different in some very important points. And I will not mention it now, but this is one example. This is from presenting in front of the students. Yep. Okay. Jeg tror du må gå opp der, da. Ja, gjør det.
We helped the minister change the law, and got, love like when you give someone love. We in the child protection service law, we got love in it, and she.
And that was a big.
Yeah, and then she gave us this lollipops, and in Norway we call this kjærlighet, love. And she congratulated us and said thank you for helping us doing this law good for children.
That was a kind of a 3-year, not a battle or a fight, but it was hard work for 3 years to explain in front of professionals first.
Because the child minister that was before her sat down a law legislative, but it was only adults or very fancy people, and we need those kind
law
of
people.
Law people, but we have felt the law on our bodies. We have lived in institutions with different kind of paragraphs on it, so we know how it feels to like be in the law. So we have to also have something to say about how should the law be for us. So we made our own children's law legislative
Committee,
yes. Yeah. So we made our own law, and we gave it to the other law people, so they could use it to, I don't know, inspiration, copy paste, stuff like that. Yeah.
Yeah, we inspired them to copy paste.
And the funny thing is that they actually used it and took some of the what we gave them in the law.
So, for example, love. When you presented it for social welfare professionals, there were lots of discussions. This is good for children. These are professional people. And is it good that we talk about love? Because love should be a family thing. There were these questions. And then you said, we need it to feel safe.
And when we feel safe, we can talk honest, and when we can talk honest, then you can help us. Because if we can talk honest and we don't trust you, then many of the things and decisions you take in my life can be really bad for me, because you don't know how it feels for me. And that is why love is so important, for me to feel safe and trust you.
And we also have talked to lots of children who have been abused, sexually abused, or experienced violence. And then we also listened to them about rettssikkerhet. Rule of law. How they feel about experiencing the rule of law, and how should it be. And this has been 2-3 years of work, and now we are presenting it this September, I think, with the leaders of the Department of Justice. They have heard about it, and they said they want to present it together with young people. And these answers are really, really challenging Norway in many ways. We cannot present all this result, but the children say that it's not safe for them in these systems, to say very short. And we will say a little bit about it. And here we are presenting it. It was statsadvokater.
State attorneys.
Yes.
Yes.
and they said afterwards, that was couple of hours with presenting the results, or some of the results, and also results attacking them. Because it is about when should the state when should the services anmelde det? Hæ? Anmelde? Note press charges? Yeah, because after a child experiences sexual abuse or violence, so the children, they ask, should we have any voice in deciding when is it going to be press charges, for example. And also lots of things about information, and lots of things about who has the right to decide all these things.
Yes.
Because you grew up in these things, and then you tell it to some adult, and then the state start
doing a lot of things. And the one I tell it to I tell it to that person because I trust that person, and because that's the one I want to tell it to. And when that person starts to go to the police and say she has been abused or something, then I lose the trust to that one person I told. And I could have waited many years to find that one person I trust. And when she goes to another person or the police and tells these things, I lose the trust, and I don't want to tell anymore. And when I don't want to tell anymore, the police can't do good work, and the one that abused me, he is going free because I don't talk, because I'm not safe.
So these are some bottom questions that we didn't know before, I think. I had no idea what the children would say about this, and I think some of these questions are also very challenging, because it's about we have to punish people doing wrong things, but
which is more important, to punish the person who are doing those things, or to make the child live in a safe place and to not have to experience more violence? What's the most important thing, and find that balance?
And the other thing, the other thing is, my dad used a lot of violence on me, but making him go to jail would just make him fatter, not any better person. And that's the other thing, that many children say that jail doesn't work. It doesn't make my father a better person or my mother. It just makes them a little bit fatter. So
because in Norwegian prisons we are feeding them very well.
And that's we need to if we not punish them, but children want them to change, but it has to happen in a way that they actually can change. You know, I would send my father in a cabin in the woods, and he had to listen on a tape where I tell him what he has done to me when he used violence for a year, then I think he would change.
And talk to a therapist, maybe.
And talk to a therapist, because I think he used a lot of violence, and he has been in war, and that does things to people, and I think that's why he did it, but he has never talked about it. So if I was going to punish my father, I would do that, because I think that would help more.
And these are, challenging answers, and we start discussing it with these people. In the beginning, it was like, ooh, and I remember one of the statsadvokatene. Yeah, he came up in the 2 years ago, and he said he was angry. He was really angry, right towards some of the pros, and said, "These things you don't know what you're talking about now, things." But now, when we met these people and discuss it 2 years later, it was different. So we have to see. This is the state secretary in the Justice Department. This guy, I think he was not shocked, but he was pretty. He was temmelig satt ut.
Was sat out, or
Yeah.
he felt a lot of things when we talked to him, because we explained to him from our hearts and gave him our advices how to.
And he said he always before heard it from professionals, so he never heard from children, young people. How does these systems feel? So somehow his idea, it was like falling, and he said, "Oh, we have to put together children." And then we put, for example, the leaders of the barnehus, children houses. Are some of you here? No, working there, and that's a good idea, because the dialogues should take it further. There is no one side has the right. It's like about dialogues. Okay. Yeah. And this is a very nice project, we think. It's called Court Procedure for the Best Interest of the Child. This is people from court system throughout Norway. I think 10 of the tingretter, the district courts, they have organized together to find the answers, what is the best of the child in the district court system. And also in straffesaker og violence against children, and when children are
doing violence or doing bad things.
Yeah, so it's all kind of all types of cases in the court.
But the good thing about this project is they start with asking the children's. How has the court? How must it be to be good for us? They start with talking with children, and then they go with these answers, and then they discuss. But they do not discuss before they have asked children how should it be.
And right now it's in between the law. It's not. There are some answers that has to change the law, but now they are finding out how can the court be more child-friendly, and the system and the information and all things around it. So it's very, very. It started in Kristiansand when you talked in front of the lots of people in the court system and lots of lawyers and lots of all these roles, and then they said we go together, because they had planned, I think, to start this project, maybe without children, but then they heard it and they said, okay, we go together. Yeah, it's okay. This is you.
This is us, a little smaller. So as you can see, I started from the wrong side. My mom liked to dress me up. So when I got older, I think that when you're getting older, you're starting to wear more nicer clothes, but I went opposite.
But we show this picture because we found out we have to challenge the court, especially for young people. How should the court think about that these are children growing up, and the history is very, very important. And if they are, for example, children punished, what place should this history have in this punishment? Because we also have listened to lots of children being punished, and what we hear is that this is no meaning in some of these cases, because they punish them, they go on punishing them, because they are punished all life when they grew up, and then they move them to jail maybe when they are 16. I guess you have the same, you understand what we're talking about. So, but this is, it's about history, and it happens also in the social welfare system when they put you on force tvangsparagrafer.
Yes, and put us in institutions where they can use force on us and put us in the ground and lock us up, and they can do a lot of things. And I think maybe sometimes we forget that the reason why I do the things I do, the reason my anger comes, and the reason I cut on myself, or the reason why I do drugs, is because it hurts in here. It's not because I'm a mean person or want to be a mean person or want to have a bad life. But when it hurts a lot in here and I don't trust grown-ups and can talk about it, then I do bad stuff. And the court has to understand that we can't going on punishing children this way. We have to come in here and fix the things that really hurts in here.
So we are presenting undersøkelse, survey for Norway now, where we talk to 50 children being used force in children welfare system. And I think the main answer on this will be, this should be risikovurdert. We should, what is that in English? Yeah, huh? Yeah, I have to, because we don't know in Norway. That's what we are saying now, that we don't know the consequences of using force like we do in the social welfare system in Norway. And like the law, the paragraphs says in the social welfare law. Because when we travel around and meeting social welfare professionals, they said they never heard this before. And they work in institutions for children, and they use force because they learned it. They learned the techniques, they learned the tools.
And they learn that it is to protect us, and they learn that it is to make us safe. But they don't know that when they do that, children say it feels like they're doing abuse again. When you take force on me, your face fades, and my father faces come up. You're not the social worker anymore. Then you are my father doing force on me. They don't know, and they don't know that I lose. I go and in destructive environments because I think it's normal. Because my father can do it, the social workers can do it. Then it must be normal.
These are examples. So we have used our time, I think. So this is some of the main points. Hvis vi kikker på der og prøver å se om vi har forklart.
One thing I just thought about is when you are talking with or having children in the court system or in those kind of roles, we have to stop talking about the rights of children. We have to ask adults, what do we as good adults working in the system need to make good decisions? Do we need the children? Do we need those children to speak, to figure out what they need in their life to make good decisions for them? And if so, how do we do that? Because we can't say about how mature you are, how old you are. You have to ask the adults, how do you talk to children? Do you talk to children so they understand you? Do they know about how important it is for them to speak out loud? Because I know that Frederick, 5 years old, and Frederick, 15 years old, could say mostly the same things if just an adult would ask the right questions and to listen carefully with their heart and ears and eyes and warmth.
But we have to do training together with children.
Yeah.
Because if we do the training, the adult,
Yeah.
then that's what we found out in Norway, that the training programs made of adults, they don't include good enough the some very, very important thing for children. Because we don't know. Yeah, jeg tror vi bare må stoppe på grunn av tid. We have to stop? Yeah. Okay.
Thank you.
Okay.
African perspective. So welcome, Julia, and looking forward to your presentation.
Thank you very much for the introduction, and thank you for welcoming me to Scandinavia. Although it might sound like I have Scandinavian origins, I actually don't. I just married somebody with Scandinavian origins. But I'm very pleased to be here, and I have to confess, I don't have a presentation, but I'm here to actually learn and to network, both from my perspective of the work I do in Africa, but also from the perspective of my position as Professor of Children's Rights at the Department of Child Law at the University of Leiden in the Netherlands, where we run a children's rights moot competition every second year, where we take in master's students as well as PhD students, and I'm hoping that maybe one or two of my PhD students can join you here at the Bergen Exchange next year. So I'm here on a fishing expedition, and recently we started the Children's Rights Jurisprudence Observatory, which will be an analysis of all the jurisprudence coming out of the judgments or the findings of the Committee on the Rights of the Child. And so we're also looking for academics who are interested in writing case notes on the judgments for us in future. And just for the record, the first judgment of the committee was brought against the government of, anybody know? Denmark. For violating children's rights in the asylum seeker regime. So you can Google Observatory of Children's Rights and read my commentary on IAM versus Denmark. So I said I'm here to fish, and I would like to just refer in my very short time to 3 projects that I've recently been working on in the African context. In the introduction to this session, there's reference to the Council of Europe Guidelines on Child-Friendly Justice of 2010. I was invited in 2011 to draft African Guidelines on Child-Friendly Justice, which were adopted at a conference in Kampala and subsequently endorsed by the African Committee of Experts on the Rights of the Child, which I was also a member of for 5 years. And then in this year, in May, the African Child Policy Forum, together with Defence for Children International and Terre des Hommes, asked me to update those guidelines. And that was launched and published as a work called Spotlighting the Invisible, Achieving Child-Friendly Justice for Children in Africa, with a strong focus not just on the guidelines and the norms and standards for child-friendly justice, but on how to reach the most excluded: girls, children with disabilities, children with albinism, children in rural areas, children who are indigenous minorities. And crucially, they asked me to write a very difficult chapter, which I had to get some assistance doing, on the position of children in informal justice systems, because it's expected that in many parts of Africa, children's main contact with the justice system is with informal justice system, the justice system of the tribal chiefs, of the customary courts, and so forth, where their invisibility and lack of ability to participate is much more enhanced than in the formal justice systems. So that document, Spotlighting the Invisible, is available on the website of the African Child Policy Forum, ACPF, if anybody would like to go and read it. It also includes case studies from a vast number of African countries, ranging from my own country, South Africa, to Liberia and Sierra Leone, because underlying the final report were also field studies that were conducted by DCI in 7 North African and West African countries, none in Southern and Eastern Africa. And I could draw on those materials also to try and fashion a way forward for achieving child-friendly justice in Africa. So that is the first reference. The second document that I've been working on for 2 years and is now complete is a general comment for the African Committee of Experts on the Rights and Welfare of the Child, which is their 5th general comment. When I checked on the website of the African Committee of Experts 10 days ago, the general comment was actually there, but it shouldn't have been there because it's supposed to first be launched. The general comment is on general measures of implementation of the African Charter and system strengthening for child protection. And I have to mention the second part of the of the title. It comes from a presentation to the committee that was done by Save the Children International in 2012, where they asked the committee to write a general comment on system strengthening for child protection, particularly in the sub-Saharan African context. So this has now been included as part of a general measures of implementation, which also includes a detailed section on juvenile justice systems, but also what state parties' obligations are in relation to strengthening child protection systems in Africa, which crucially includes so many of the things that were referred to by the team who presented the IDEA project, such as training of professionals, specialization of professional coordination between different professionals, and so on and so forth. You'll be probably all very familiar with this. It's just been put together in a neat document. So general comment number 5 is probably still available on the website of the African Committee of Experts on the Rights and Welfare of the Child, because it has been adopted by the committee. It just has not yet been launched. The party hasn't taken place. And then my final reference, and maybe my most important fishing expedition today, is the work I'm doing at the moment for the Department of Rural Development in Botswana. Botswana is a neighboring country, very interesting country. It's classified as a middle-income country because they have a lot of diamonds, and they've used those diamonds very well, not to enrich themselves, the leaders, but to further the development of their population, education-wise and nutrition-wise. It's a very large country, and the middle of it is a completely desert, and it has only 2 million people, so it's very sparsely populated. And there was a wonderful movie, I think 2 years ago, that won many awards that detailed the succession of the then King Sir Seretse Khama to the throne in the UK. I just can't think of the title of the movie, but it also portrays the very conservative nature, very patriarchal nature of society in Botswana, and the fact that it is highly based on chieftainship and on the rule of the leaders of the community, even now. So what am I doing in Botswana at the moment? Botswana developed a new Child Care and Protection Act in 2009. It's been slow to get off the ground, but there's now the contract that I've signed to develop a toolkit for social workers to implement the Children's Act. So in our deliberations with the people who are commissioning it, obviously UNICEF as well, I realized that a toolkit is something between a training manual and a textbook or whatever. I can easily write a textbook, but that doesn't help the social workers at all, given the difficult context under which they work. The rural people placed in rural communities don't have computers, they don't have access to the internet. Even the regulations to the Children's Act are not available even to me in online format or in electronic format. I had to go physically to Gaborone and collect a written copy. So I've divided the toolkit into 8 sections, which will all be between 10 and 20 pages, no more, because my tendency is always to write lots of footnotes and Latin words and so forth. One on children's rights, the second one on child development, third one on the contents of the Act, a fourth one on children's courts and the social worker's role in children's courts, fifth one on child abuse, sexual abuse and trafficking, a sixth one on interviewing children and the role of the child as a witness, the seventh one, which I have not yet started, on children in conflict with the law, and then the last one, number 8, will be on the social worker's role in coordinating the other role players, police, village, child protection committees, and so on and so forth. I started collecting materials for the toolkits based on work I did in Namibia. I did the work originally in 2013, but the work got lost, computers crashed or something. So the work was redone over the whole of last year. And this work was on drafting modules on child protection, sexual violence, and domestic violence for the Namibia Police Training College. This was even more challenging because some of the police are not actually literate. So much of the work has to be done with pictures, with using experiential learning methods, and then training the trainers to be able to do that. So to conclude, and I am concluding now, I've had to scout far and wide to find suitable materials that can be translated, used, adapted to these contexts, one for the police, that is complete now, and one for social workers that cannot rely on electronic assistance like PowerPoints and URLs that people can go into. And so I'm very keen to collect any examples that you have to offer. I found one a very useful resource being a recently released toolkit on child development, which is online, released by an organization called Disaster Ready, on child protection, building resilience, toxic stress, and things like that. These are, I'm a lawyer, so these I have to go and copy. So I literally have to go and do the video and then stop it and go and copy all the words and then rerun it and so on. But I also have the sense that there could be generic training materials developed so that other countries could use these without having to reinvent the wheel, based on particularly the experiences we've heard of the IDEA project, which I think is common not just to countries in Europe, but also to countries in Africa. Thank you.
Okay, thank you very much. I've just realized that we've almost run out of time, but I've been told that we have time for a couple of questions at least. So, can you hear me? Yeah, you can hear me, okay. But maybe any specific questions for the profs we could maybe leave for the next session. So maybe focus for now on questions that involve sort of the IDEA project or what Julia just told us about Africa, or sort of in more general terms on the topic of child friendliness and justice. Any questions?